So welcome to Get It Right with Atara Solutions. Yes, you are tuned in to Get It Right with Atara Solutions. This is a webinar series that seeks to demystify issues in employment and entrepreneurship. We do this every Tuesday from 8 p.m. to 9 p.m. If you're joining us for the first time, Karibu, welcome. We are honored to have you. We do not take it for granted that you dropped everything to join us this evening. And so we are privileged to have you. And I hope that this session is going to highlight something that will help you do your jobs better. We are on a mission to change the world through information. And the purpose of this webinar series is to demystify issues in employment and entrepreneurship. So, and with me, of course, is my co-host, Catherine Sidandi. Catherine Sidandi is our sign language interpreter. She supports us in being inclusive. Welcome, Catherine. It's good to see you again this week. And if any of you is actually looking for sign language interpreter or a social worker, please get in touch with Catherine. She's looking for a job. Sorry, Catherine, I had to say it. Yes. Catherine is currently looking for a job, and all of you are here. Most of you are employers and HR professionals, and also leaders in your departments. So if any of you is looking for a sign language interpreter or a social worker, then Catherine Sidandi is available for a position. And then, of course, with me is my other co-host, Mr. Kevin. Kevin, you can introduce yourself.
Hello, good evening, good morning, good afternoon from wherever you are. As you have, my name is Kevin Adipo. I co-host Grace in Get It Right with Atara Solution. And I'm always excited to be here with you and to be here with everyone. Today being the very end of February, we are ending it or winding it up with Disciplinary. I hope all of us here are ready and can't wait to hear this topic. Back to you, Grace.
All right, thank you very much, Kevin. It's always a pleasure to have you, and we appreciate that you also are part of this. And I hope that everyone who is tuned in on Facebook, we are still aligned. We are together. So yes. All right, so Get It Right with Atara Solutions is brought to you by Atara Solutions. Atara Solutions is a HR consulting and training firm for all your consulting, for all your HR needs end to end. And for all your training needs, please, we are a one-stop shop for training, and we'll be able to provide you with those services. Get It Right with Atara Solutions is again brought to you by Atara Solutions in partnership with a number of organizations. And allow me to just give them a quick mention. We have Balcon Housing. Balcon Housing is a real estate and property management company. If you're looking to invest in a piece of land in Nairobi, in Kenya, because they're all over, you would need to seek the services of Balcon Housing, or if you own a piece of land and you wish to sell it, then Balcon Housing will be able to do that for you. We have Stallion Construction Company. Stallion Construction is a construction firm, as the name spells it. If you're looking to renovate your house, you're looking to renovate your premises, if you're looking to build a house or anything to do with building and construction, then Stallion Constructions are people for you. And then we have Pathway Solution Services. Pathway Solution Services is a HR consulting and training firm. They have been offering our audience free training sessions on their LMS. LMS is Learning Management System. They offer trainings in all aspects of leadership, HR, and among other self-development and entrepreneurship courses. I think when we were hosting Mr. Washuri, about 5 people got a chance to train with Pathway Solutions on their LMS on Entrepreneurship 101. So we are grateful to you, Frank. Thank you for your partnership. Thank you for being with us in season 3. Season 3. And then we have Institute of Pension Management. Institute of Pension Management, like the name spells it, is involved on matters pension management, but as well, they have a college that offers CHRP, CHRP, Certified Human Resource Practitioner or Professional, and they are located on Ojijo Road. They have online classes. So if you're a HR professional here and you wish to become a Certified Human Resource Professional, then you need to get in touch with us or seek out the services of Institute of Pension Management. They also organize a few other specified HR courses. So Institute of Pension Management, we appreciate your partnership. The Panessa Training Institute is into woodworking. If you're here and you're looking for technical skills in working with timber, then Panessa Training Institute would be your choice. And then we have WeClean. WeClean is a carpet cleaning company, or it's actually a cleaning company, but they have a machine that cleans carpets within 6 minutes. So they are able to do a 24-hour delivery. So they pick up a carpet today and they can deliver it back tomorrow looking like new. My carpet was picked yesterday, it was returned back. And then the beauty is I don't have to struggle with lifting furniture. The team comes, they lift furniture, they take the carpet. Then when they bring it back, they tandika for you. I don't know how to say that in English, but yes. Then we have Suluhu Mediation Center. Suluhu Mediation offers mediation training. I am currently a certified professional mediator. I did my training with Suluhu Mediation Center. They have online classes that go for a week and their training is awesome. It is thorough to the point. Oh my God, I really enjoyed. I didn't know how I would last a whole week of online training, but I tell you, I could not even realize that it was 5 o'clock. They are engaging, they know what they're doing. And then we have Profiles International. Profiles International deals with everything psychometric. If you've seen, and for the HRs in Kenya, if you've seen Nelson's flyers, he's hosting Vicky Karuga on Thursday on the Tech Talk. And Vicky Karuga is the queen of psychometric tests. She is also the queen of Gino's Emotional Intelligence, a certification course on emotional intelligence. She is just amazing, by the way. She understands human beings. She runs self-discovery. She owns DISC. So if you want to discover yourself, Profiles International, they have psychometric, they have DISC assessments, they have Gino's Emotional Intelligence, among other things. And then we have El Samea. El Samea is a hotel located in Naivasha. It's a conservation center. It's one of the most beautiful places you can ever visit when you're in Kenya. They have a beautiful view of Lake Naivasha. It is quiet. It is, by the way, if you're looking for a romantic place, then El Samea would be the place. If you're looking for a place to unwind, El Samea is your answer. If you're looking for a place to just be, you know, the state of being, then El Samea would be your best choice. And then we have Kapula Mintito. Kapula Mintito deals in coastal snacks. For those of you who are coming for women in HR, let me know. I'll order for you special mabuyus and you'll understand what I keep talking about. And then we have Purpose. Purpose is a technology company. They have an ERP system that is fantastic. We actually are using their ATS. ATS is an automatic tracking system. And that is what we're using for recruitment, and it's seamless. It's awesome. You ought to try them. And then, of course, I wish to take this opportunity to invite you for the Gino's Emotional Intelligence Practitioner Certification, which is happening from the 15th of March. This is brought to you by Profiles International at the cost of about $1,500. This is one of those courses that you actually need. My good friends, if you know what is good for you, please sign up for this emotional intelligence course. And I know somebody from Profiles is probably posting on the chat. And of course, we have women in HR. We are celebrating International Women's Day at the conference. We have the Women in HR convention coming up next week in Mombasa at the Sarova White Sands. This is one of those things that you cannot afford to miss, my good friends. So we will be there from Wednesday next week. Wednesday is when? 8th. For International Women's Day, and we'll be there for 3 days. We have Sarah Richson as one of the speakers, Frida Owinga, we have Esther Katiba, we have Florence Oginde, we have Henry Opondo, who is an expert in public speaking. We have a good pack. I mean, we have Mildred Ngesa. She fought cancer and she's coming to share her story in fighting breast cancer. So you guys cannot afford to miss. Please get in touch with us and we'll be able to link you up. All right. Now, enough of my people, because we need to do to give, you know, Zoom is very expensive. So don't start telling me that I'm taking a lot of time advertising. You have no idea how much it is to pay for Zoom every month. and you're not charging people, you're giving a service for free. So allow us to also give a shout out to the people who believe in our journey, in our vision, and we are here. So without further ado, allow me to get right on to the business of the day. And we are privileged and honored to host Mr. Brian Kwame Emurwon. Brian is an advocate of the High Court of Uganda with over 16 years post-qualification experience. He's the managing partner of Emurwon and Partner Advocates, a boutique law firm in Uganda that specializes in employment law. In 2016, Uganda's Ministry of Labor and Social Development appointed Brian as the chair of a task force conducting a review on the Labor Disputes Act. The task force made proposals for amendment of the law that approved by cabinet in 2019, enacted by parliament in 2020, and received presidential assent in 2021. Is Brian, eh? And you're not mentioning, my friend, you're not mentioning. And then the Ministry of Labor also engages Brian to provide induction training to labor officers from all over regarding their response. Okay, so he provides the services to the Ministry of Labor. Brian is extensively involved in advisory litigation capacities in numerous employment cases before labor officers and before the industrial court. So my good friends, don't worry. I'm sure maybe Kenyans are wondering, Brian, my friend, relax. We are in very good hands, Buana. All right, so Brian, you know, we in fact, I had a conversation with one of the people who are very involved in matters employment in this country. I met them today this afternoon, and they were saying that in fact, I was asking, how come we always have employers winning cases in court? I mean, not winning, losing cases in court. It's like every time a labor matter goes to court, it is almost as certain that the employee will win. I know some don't, I mean, we never see the light of it because it doesn't make news, but still, how do we protect our employers? How do we, because we have, I think 90% of people logged in here are HR professionals or HODs. How do we protect, and especially because we all know that we need to write show cause letters. But after that, we have no idea. Okay, maybe we do, but still, please enlighten us. How do we conduct disciplinary hearings?
Okay. Is my mic on? Yes. Good evening. I'm so glad, Grace, to have this opportunity to interact with you and interact with all the people who are logged on online. Thank you for making me sound like I do very serious things here in Uganda. Even me, I was getting scared of myself. If I can give a little bit more of introduction about myself, I started my legal practice in government. I worked for the Office of the President, and actually my work essentially involved getting treaties that Uganda has signed, particularly anti-corruption treaties, and trying to domesticate our obligations, our international obligations, into Ugandan law. So that is what I did for a number of years, about 3 years. Then I jumped out of there, out of government, and now joined legal practice. Actually, no, I went for a master's before I joined private practice. I went for a master's in South Africa, which was very enlightening for me because in South Africa marries what we call common law, which is what we practice in Kenya, Uganda, Tanzania, and something called civil law, which is European law. So South Africa has a way it tries to marry those two different, should I say, legal processes. So being there opened my eyes and said, oh, there's actually a different way of doing things. It's not everything has to be done the common law way. And one of the key things I studied during my master's was how to express how to write legally, how to get concepts and things that people want to do and say, which I was already doing in government for domesticating the treaties, but now to simplify them so that someone who is not a lawyer can actually grasp and use an instrument written by a lawyer. So that was the main thing I learned in South Africa, that laws should not be where you read, you pick up the Employment Act, you start reading it and say, oh my God, I need to run to Brian to tell me what this means. South Africa taught me that a law should be something that is drafted where Grace can pick it up and run with it without having to run to the professional. So coming back from that is when I joined private practice. a big law firm called Emurwon, and was doing everything that commercial lawyers do. Did that for a number of years. And then I said, okay, it is time for me to spread my wings and try and build my own name. And it was around that time that somebody in the Ministry of Labor said, hey, we're trying to launch the industrial court in Uganda. And there's this guy who used to know how to domesticate those anti-corruption policies. Can we get him to help us streamline the operations of the industrial court? So around 2014, when I was leaving my employment to start being self-employed, is around the time they were launching the industrial court in Uganda. And so I joined the ministry and I helped the ministry develop the court and operationalize it and advise the ministry, advise the court, it just became whatever comes up. Brian, please help us with this. Labor officers need training. Brian, please come and train the labor officers, etc. So as I got into that more and more, I said, you know what, instead of trying to do everything in law, why don't I specialize in employment law and do the best I can in one particular area and actually be good in that? And it led to me giving a lot of training, such as what I'm doing now. And then from the trainings led to litigation and cases and servicing specific clients. So today you're actually throwing me back to my beginning days of rolling out and explaining these concepts and trying to share the knowledge that I've gathered over the years. So I am very grateful to this opportunity to go back to that and enjoy what pulled me into this in the first place. Yeah. So basically that is the background of how I got into employment law. And in another blessing of my life is even right where we are at right now. This is my law firm, and across the road from my law firm is the industrial court. So not only do I specialize in employment law, but I'm just across. When I'm ready for my case, I just get up, cross the road, and I'm there. So I'm very easy to find. Yeah. So that is me in a nutshell and what I do in employment law. I've had the opportunity to go to Tanzania and study how they implement their employment law, how the courts practice, how the labor officers practice, the mediators, etc. I am waiting for your invitation to come to and enjoy White Sands Sarova, even though I am not a lady HR practitioner, but I would be happy to come to Mombasa, because that is actually my birthplace. I was born in Mombasa, so I'm a honorary Costarian. Yes. So with that, without further ado,
welcome. You are welcome, Brian.
And you must have a packet of mabuyu for me.
Oh, definitely. And before you start, please allow me to recognize the presence of Herbert Zake. Herbert Zake is my good friend. And let me just, at the risk of it, call him my partner in Kampala. And he introduced me to Brian. So it would be unfair to start this webinar without recognizing him and his presence and his impact. Thank you very much, Herbert Zake. And we appreciate what you do with us and for us. Thank you. Back to you, Brian.
Okay, super. So I have scribbled a few notes. They're 10 pages long. This kind of presentation, I usually take 3 hours. I'm going to try and condense the 3 hours into 20 to 30 minutes, of which I think 10 are already gone with my long stories about the personal history. Anyway, okay. Launching into these notes, I hope they will flow very well and we will be moving together. Rule number one, and to explain, the topic is conducting disciplinary hearings. But before jumping into the disciplinary hearings, I want to take us back to just before the disciplinary hearings, because I feel that is the heart of the preparation before we jump into the disciplinary hearings. And these are my key notes that I give my employer clients when I'm trying to give trainings to the managers, HR managers and supervisors in the companies. So my rule number one is from the field of medicine. Prevention is better than cure. What do I mean by this? We usually examine how well we have conducted our disciplinary hearing when the employee has dragged us to court and they're litigating against us. So my rule number one for employers is do not let things even get to that point where the employer is suing you. And I have 3 reasons why I say prevention is better than cure. Reason number one is that labor officers usually are not required to have legal training. So you may have carried out your disciplinary hearing very well, observed the rules and principles of natural justice, maybe even brought a lawyer on board, a Brian on board to advise the company. But when that case is now before a labor officer who is not as well trained, perhaps you may be lucky and land before a labor officer who's well trained, but chances are they'll be half-baked. And so they will not appreciate all the reasons and all the good legal considerations that you took in mind while carrying out this disciplinary hearing and firing this employee. So it is a gamble whether you will land before a good labor officer or not, before it actually goes to court. So that is my reason number one. Prevention is better than cure, because the labor officer may not handle you the way you feel the law entitles you to be handled. Now, reason number two is that employers lose most of the cases. The survey that I've done in Uganda is Ugandan employers lose about 55% of all cases that are litigated before the industrial court. I don't know if the percentages are better in Kenya, but from what Grace has told me, it seems to be even higher than 55%. So if you know that most of the time employers lose, then let's not even take the risk of ending up in court. So what steps do we need to take to make sure we don't get there? That is what I'm going to discuss later on in the course of my presentation. But reason number two is employers lose most of the cases. So having that in mind, let us not even get there. And reason number three is, even if an employer wins, you have lost money hiring lawyers, you've lost time sending your staff to sit in court day after day, week after week to handle these cases, when they could be in the offices creating value for the company and moving the company forward. So even if you win the case and let's say recover some of your costs, at the end of the day, the loss is very high. And even when the court says, Brian has lost the case, Brian, this staff member you fired, let him pay the costs. Brian tells you, but I'm poor and I'm broke and I'm jobless. Where are you going to get money out of me? So even though you've won on paper, it may be hard to recover the money in real fact. So for these three reasons, I say let us not even get to the point of fighting it out there in a litigation with the employee. So that is my first point of the evening. The second point of the evening, and I hope I am not moving too fast, I'm just trying to squeeze everything in the time we have. My rule number one is prevention is better than cure. My rule number two is the progressive approach. This is linked to rule number one. The progressive approach for an employer is best. What do I mean by progressive? Before we even get to the disciplinary hearing, there are other processes that you could have done before, of warning letters, reprimands. That is what I mean by progressive is best. And why is progressive best? Again, I have three reasons. When you are vigilant to warn your staff about the small things of you came in late, you are absent one day, etc., and you document those and you put them on the file, by the time Brian, who's this hard-headed employee, gets to the point where you're saying, you know what, we want him out of the company, let's have a disciplinary hearing about this other serious thing, you'll have a nice thick file of warning letters of the other things that Brian had already done before you got to this big thing. Usually the mistake that my clients have, my employer clients, is they are so merciful before that when Brian is doing all these other smaller wrong things, they don't keep a record. And then when it's coming to the disciplinary hearing, they call me in and say, Brian, advise us on how to fire this person. They have been a headache employee for the last 1.5 years. Now we've reached, and then I tell them, okay, show me all the little things they've been doing for the last 1.5 years. They say, we've not been recording them. So if you've not been recording them, this employee, once they're fired, they run to a labor office and say, no, I've actually been a star employee in this company. This is the first time I'm in trouble. Let them bring my personnel file, etc. So my reason number one is keep track of the small things, and the small things will prevent the big things from happening. That is reason number one, to always, even if it is late coming, give a warning letter, put that warning letter on file about the late coming. Reason number two, when Brian has been that headache employee for a 1.5 years, and there are, let's say, 10 warning letters or reprimands on his file, and then finally you have that disciplinary hearing and you fire Brian, he'll sit at home and say, I think I want to go to the labor office and complain about this dismissal, but I know there are like 20 warning letters on my file. If my file is presented before this labor officer, he'll already be biased. Let me just relax. No. So when Brian knows there is that kind of evidence against him and he's been fired, he will think twice before filing the complaint. But if Brian knows, yes, they used to warn me about things, but there's nothing on that file. The only thing on that file is the notice to show cause, this one letter, the disciplinary, that is all that he says. I'll go to the labor office and lie my way and pretend I've been a wonderful employee before. So taking a progressive approach where you handle those small offenses, the ones that you are not for firing anybody, handling those ones and documenting those ones supports you and prevents the employee from lodging a complaint against you when you finally have a bigger problem with them and then you've actually fired them. And then now reason number 3, if Brian decides, you know what, I have 10 disciplinary warning letters on my file, but I'm going to risk it and go and complain to a labor officer anyway. When you show up, let's say the labor officer calls you now for a mediation hearing, whatever. You show up and say, Mr. or Miss Labor Officer, we fired Brian because of ABCD, but before we fired him, look at all the chances we gave Brian to try and correct himself and be a good employee in our company. We gave him all these warning letters. We've really been patient with Brian. Once the labor officer sees that, he just says, you know what, Brian, look at all the chances these people gave you. I think you're the problem. I don't think the problem is this company. But when you show up for a mediation, etc., and the only thing you can talk about is this one incident, which was now the tipping point. It was the camel the straw that broke the camel's back, and you don't have a history of it. It makes it more likely than not that you will lose the case, because the labor officer will also be sympathetic to the worker and say, you know what, if I keep telling all the workers that they were justifiably dismissed, mimi pia sitakuwa na kazi. They'll say, don't go to that labor officer. He always favors the employers, and the labor officer also wants to have a job. So it is your job as the HR person, track these small things. Whenever you're called in, you say, you know what, this was the straw that broke the camel's back. Look at the history of this person. And so that is why I say progressive, that is the advantage of the progressive approach. That one, you warn the person so that they know even the small things are serious in this company. Let me not even risk doing the big things. 2, when you fire them, they say, there's a good history, track record in the file that tracks how I've been a headache. Let me not even go to the labor officer. And 3, when you show up before the labor officer with your record, the labor officer says, really, Brian, they gave you chances. Really, just go home and relax and think about what you did. So that is the advantage of a progressive approach. Okay. Reason number 3, moving on to the next reason why most employers lose before labor officers, before the employment court, the employment tribunal, is found in Section 68 of Uganda's Employment Act and Section 43 of Kenya's Employment Act. That section says, you know, there is that general principle that everybody is presumed innocent until proven guilty. Now, these sections say the reverse. Section 43 of the Employment Act of Kenya says, an employer must prove why they terminated Brian. It is them to prove the reason why they terminated Brian. And if they fail to prove the reason why they terminated Brian, the termination is unfair. So that means when Brian goes and reports and says, Atara Solutions fired me, that is all Brian needs to say. The court says, Atara Solutions, you are already presumed guilty. It is your job now to prove that you are actually innocent. And that is why you find 55%, 60, 70%, 80% of the cases the employers lose, because the employers go into the thing thinking it is Brian to prove that I dismissed him unfairly. No, it is actually the other way around. It is the employer to go and prove that I actually dismissed him fairly. If you fail to prove that you dismissed fairly, the dismissal is just automatically assumed. From the start, it is assumed to be unfair. It is your job to make it fair. So your starting point is on a disadvantage, you're on a back foot. But most employers think, no, we go to court, he's the one suing us, he's the one to prove his case. No. All he has to prove is that they fired me. Once he has proven that he was fired, the court says, now you prove to us the reason why you fired him. So employers, please let us understand that we are already presumed guilty and we have an uphill task of proving our innocence. It is not, we are not presumed innocent. Okay, let me try and run through these things. All right, so now we jump into the 4 basic elements of a disciplinary hearing. This is the anatomy of a disciplinary hearing that are the same both for Kenya and Uganda. In Kenya, they are found in Section 41. Well, let me not say the same, almost the same. I'm going to point out the differences between the two. This is found in Section 41 of the Employment Act of Kenya and Section 66 of the Employment Act of Uganda. The 4 main elements of any disciplinary hearing whatsoever. Number 1, and I'm going to expound on them in detail, but I want to give the headings. Number 1 is notification. Number 2 is explanation. And this one, before I even go to number 3, this is the one that a lot of employers skip and miss. Number 3 is the hearing itself. And then number 4 is consideration. Let me say them again. Notification, explanation, hearing, consideration. Now, let me break down what those 4 entail. Grace, you talked about a notice to show cause hearing. That is a favorite procedure for a lot of Kenyan companies in Kenya and a lot of Kenyan companies that have branches in Uganda. They have a notice to show cause hearing. A number of my clients are actually Kenyan companies that have branches here. Notice to show cause are not a requirement under Ugandan law. And for the purposes of this presentation, I did a bit of reading of Kenyan cases in employment law. And the Kenyan courts also say there's nothing like notice to show cause in our law. It is just a practice for HR professionals, but we don't care whether you do it or you don't do it. So I found that very interesting. Exactly. I found that very interesting. I'm like, okay, I thought this thing was in Kenya. Why do all Kenyans have a tradition of notice? It is not in your law. And even your courts are saying, Apana, why are you people doing this? We don't care. As we jump straight to the nyama, we jump to the hearing. We don't care what mistakes you made in notice to show cause. How did you handle the actual hearing as you are required under section 41? So interesting point number 1 is if you have notice to show cause, it is you just giving yourself work. It is actually not required by your law. It is not required by our law. Let me drop that point and move on to the next one. Right, notification. What is notification? Notification is not the notice to show cause. As I've said, it is not even there. Notification is the letter you send to tell Brian that, Brian, we suspect that you embezzled 20 million shillings and we want you to come for a disciplinary hearing. Today is Wednesday. Today is Tuesday. Next Tuesday at 10 a.m. at a place to be disclosed. That is the notification that you send to the employee. You're telling them there's a disciplinary hearing on the horizon. The disciplinary hearing will be related to this offense and they should come. What else you want to tell them in that notification is some of the rights. Like you have the right to have a representative at that disciplinary hearing. You want to put it in there. Number 1, to remind yourself. And number 2, if it ever comes up where the the worker says, they never told me of my right to a representative, so I went there alone for the hearing. Then you have to rewind and say, okay, now you know, go back and find that representative. So put it in the notification and the person knows to come. Okay, what's that? Sorry. Yes, so you send the notification. Now moving on to explanation, this is now the key part. A lot of employers, and I believe this is actually where a lot of disciplinary hearings take a left turn into illegality. A lot of employers, once Brian has showed up now for the day of the hearing, they tell Brian, Mesoma hii barua? Yes. Okay, what do you have to say for yourself? So the hearing starts from, Brian, present your defense to this thing we sent you last week. You get? That is where most disciplinary hearings launch from. No. Section 41 and section 66 of the Act say, no, before you ask Brian to do anything, you, the employer, you have a duty to explain to Brian what is the case. What is the issue? Why do you want to fire him? What did he do wrong? Which section of the HR manual has he broken? You break it, all those things down and explain everything to him in a language that he is expected to understand. Kama ni Kiswahili, ni Kiswahili. If it is English, it is English. You explain that. Once you've finished that explanation, that is when now we move on to phase 3 of saying, let us hear what you have to say. We have explained to you what you wanted the charges you have to face. Now we want to hear from you what you have to say. Now, most employers, when I explain this to them, they say, but the letter, the notification we sent already explained to him what is coming into face. Why do we? That was it. We have fulfilled that obligation. But no, the sections 41 and 66 say this explanation to the worker must be done in the presence of the employee's representative. Ulipomtumia hiyo barua, it was Brian reading the letter by himself. So he shows up for the hearing. You have not explained to him in the presence of the representative. When Brian shows up with Kevin and says, Kevin is my representative, that is now, we move to phase 2 of saying, okay, Brian is here, representative is here. Let us fulfill our obligation of explaining what the offense is. So that is obligation number 2. Now that second thing, that explanation is not done by the committee. That is the second or third sin that is committed by employers. Before this hearing happened, there was an investigation. The explanation of the case that Brian has to face should be presented by the person who did the investigation, and he's presenting that explanation to Brian and presenting that explanation to the committee. And that person, the investigator, is not part of the committee. It's like a third person. It is like a case where, let us take like a criminal case. DPP is presenting the case that Ujama stole ABCD. This is the case, evidence is here, etc. And the judge is listening. The way the judge is listening, also the disciplinary committee is listening and saying, okay, where is the evidence? Which employee, which saw this happening? Which documents do you have to support, etc. The investigator presents all that stuff, and Brian is listening. Then the committee says, Brian, you've heard what the investigator has said. Now let us hear from you. That is how we now move to part 3. And actually, one more thing, before we move to part 3, when the investigator has given all those explanations, the committee is supposed to tell Brian, you've heard what the investigator has said, what the witnesses have said. Do you have any questions for them before we switch to you? That's again another thing that even in the cases that I've read, the Kenyan cases that I've read about where employers go wrong, usually the case is finished like this, and then they turn to the worker and then say, now you defend yourself. And your Kenyan courts have said, no. When this explanation is over, now ask Brian, does he have any questions for these people who have presented this information? Brian, awaulize all the maswalis and say, but you said that document, did I sign? Is that my signature? All the questions that Brian has to ask them, he asks them, the committee makes a note of them. Once they finish all that, then they say, okay, all these witnesses out. Investigator, you can stay. Now, Brian, let us hear your side of the story. Then Brian, now that is now the hearing. And there's a big difference here when we move to phase 3. There's a big difference between the Kenyan procedure and the Ugandan procedure. And I'm highlighting this difference because a lot of I presume a lot of the HR managers who are online right now are HR managers of Kenyan companies and Kenyan companies that have branches in Uganda. So it is good as you manage your people at home to also know what your people across the border are required to do. Now, when we move to the hearing part of the procedure, this is step 3. In Kenya, it says you just continue. You finish the explanation, you move to the hearing. But in Uganda, it says the worker has a right to say that, okay, now that the thing has been explained to me, I need more time to now go back. Now I've understood what the case is. I need more time to go back and prepare my defense. So adjourn this hearing, I'll see you next Tuesday. That is a right in Uganda, but it does not exist in Kenya, unless it is existing in practice, but it is not in your law. But our section 66 says the employee can put a comma on the hearing and say, okay, asante very much for that explanation. Can I take a few days and now go and digest and prepare my defense? I had not understood before today what the case really was. So if the employer, most cases, the employee says, I've understood, I'm ready to present my case. So now we move to the hearing. The committee now tells the employee, we have heard from this other person, can we also hear from you? So the committee again hears. Brian talks and says, ABCD says, Kevin is my witness. He even saw that I wasn't there that day. I was sick. I called him from the clinic, let him show you the WhatsApp I sent to him, etc. Brian presents everything that he has to say. And the committee is simply making notes. They've been making notes while the investigator was presenting. They've been making notes while Brian is presenting. We move on now to phase 4, consideration. And this is the easiest part. When you get to consideration, whoever is chairing the committee, it may be a one-person committee, a several people's committee, all they have to do at stage 4 is tell Brian, the investigator, and tell Brian, we have heard, remember, this is a disciplinary hearing. We have heard you, thank you, step out. It is now our time to sit down and think about everything we've heard from everybody, and we'll come up with a decision. And you close the disciplinary hearing. It is that simple. Step 1, notification. Step 2, explanation. Step 3, hearing. Hearing from the investigator, hearing from Brian. Step 4, close the hearing and say we are now going to consider the evidence. Another mistake or temptation the disciplinary committee has is to be the ones now interrogating Brian. They feel this is the case that has been presented. Kazi yetu is to pin Brian and even get Brian to admit that he did ABCD wrong. I advise my employer clients, the less I hear from the chairperson and the committee members, the better. If they don't even say mwe, that is when you're on a solid ground, because they will sit, the whole time the investigator is talking, they're just there scribbling on their things. Brian asks the investigators whatever questions, they make note of the questions, they make note of the answers. Then they tell Brian, Brian, your turn. Brian talks, they make their notes. Investigator asks Brian's questions, they make note of the questions and the answers. They finish, they tell both of the people, thank you very much for everything you presented, out you go. End of story. It can be that smart. At the end of the day, you give your finding, either he's fired or not, but you have the minutes showing investigator presented everything, Brian presented everything, the hearing was fair. Now, when the committee itself starts pinning Brian and asking questions, etc., then the minutes will show the committee was not a balanced committee. The committee was trying to do the work for the employer of pinning Brian. That is why I tell my clients, whatever questions that the company wants to ask Brian, those questions should be asked by the investigator. It's the investigator to ask Brian, where were you at this time? Let us see that WhatsApp, whatever. Those questions should not come from the committee. Because when the committee asks those questions, Brian says, you see, the committee was ganging up with this investigator against me. I did not get a fair hearing. All those people in that room had already made up their minds that I was guilty. So the less the committee does, the better. Let them be completely quiet. It should really even be the chairperson to just guide the procedure. And I'm going to jump into the work that the committee chair should do. Yeah, sorry, I'm getting distracted by questions here on the side, but we will deal with those later. Okay, so those are the steps: notification, explanation, hearing, consideration. I can expound more in the Q&A. So, and this actually will address, there's a question here about who should do the investigation. So now now that we've gone through the 4 steps of the hearing, I want to jump back slightly to before the hearing and say, what do we need to do? And the things that need to be done by the investigator. So the 3 things need to be done. Number 1, the investigator, I'm getting distracted by the question, sorry. The investigator needs to be certain of the offense that they are charging Brian. That means you have the facts of this incident that happened, but having those facts, you need to jump back into your HR manual and say, the offenses we've listed in the HR manual, which is the one that actually fits this offense. And that is actually where I recommend, during this process of wanting to be certain of the offense, my recommendation is this is the time to call your lawyer. If the company has an external lawyer or even an internal lawyer, you call the lawyer and say, hey, this thing happened in the company the other time, Brian did ABCD. These are the facts, please guide us, which is the best offense we should put against Brian. And my rule for picking the offense is, once again, I think I'll jump into medicine. In medicine, the principle is give the patient the lowest effective dose to treat the disease. If 2 pills of Panadol are enough to take the headache away, do not give 20, okay? So if you look at the facts of the event, whatever happened, and then you look at your HR manual and there are about, let's say 7 different offenses that you can charge Brian. If I am the lawyer advising the organization, I say number 1, out of the 7, pick maximum 3, but ideally it should even be 1 offense. And pick the offense that it requires the least amount of work to prove the offense, but is enough to exit Brian out of the organization. There is no need to pick fraud when negligence can do, because fraud is a very high bar that you have to jump over, whereas negligence is enough to push the person out. If you even have previous warning letters, etc., so pick, do not give yourself a very hard task to do. If you pick 7 offenses, now you have to give yourself the task of finding evidence to satisfy all 7 offenses. So my maximum is 3. Pick the top 3. If it is even 1, the best. Just pick 1 offense and say, this is it. Another reason why you want to do this, in the flyer, you talked about how we should be humane in the disciplinary process. Remember, when you exit Brian out of your organization, you don't want to end Brian's life. He should be able to have a job elsewhere. So you may have all these 7 things that you can do, complain about him. But when you complain about all those things and put all those in a dismissal letter, where is Brian going to get another job elsewhere to feed his children, etc.? So you say, okay, yes, much as we can pin him on all these, but there should be life for him after this, the job here. So you put on the human face and say, what is enough to exit him out of the organization, and what he can also learn about himself and improve. I'm jumping to another part of the presentation, but that is it. Pick the least effective offense to exit Brian. Number 2, once you've picked the offense, double check and say, does our HR manual say that this offense, the penalty for it is dismissal? I'll give you an example. A client of mine went through a disciplinary process for negligence and was ultimately dismissed by his employer. And when I sat down and looked at the HR manual said the penalty for negligence is warning letter. So I am waiting for my day in court to cross-examine their HR manager and tell them, okay, you fired my guy for what? Negligence. Can we go into your HR manual? What is the penalty? And the HR manager will start seeing stars in court. I hope they're not logged on to this online session. They might be getting advanced info on what's in store for them. So be sure of the offense, be sure of the penalty. Once your HR manual tells you, yes, the penalty for this is dismissal, then you know I'm on solid ground. Now you say, okay, do we have enough evidence to present as the investigator to prove this offense that I've picked? And once again, that is when the lawyer comes in and advises you and says, yes, this letter here, this email, what he told so and so. That is when your in-house lawyer or external lawyer comes in and helps you in preparing this, the investigator preparing this. Boom. So that is what needs to be done. I've looked at the law in Uganda, I've looked at the law in Tanzania, and our law and the law in Kenya, and even your cases say there must be signs of an investigation before even the disciplinary hearing, because it is the findings of that investigation that is being presented to the committee. The hearing should not be when the investigation is happening. No, the investigation should have happened before you sent even out that notification. So that the role of that hearing is for the investigator to present the findings of the investigation to the committee. It is not for the committee to now sit and say, Brian, you're here, we're now going to investigate. What did you do on that day? No, that is not the role of the committee. Yet that is usually what happens in disciplinary hearings, especially in financial institutions. If there's an HR officer here from a bank, that is what you guys do. Your hearings are investigatory hearings, yet the investigation should have happened before. So that is the mistake. The investigation happens before. At the hearing, you have somebody presenting the findings, and then the committee is saying, Brian, what do you have to say about what the investigator has said? And then Brian says what he says, and then you close the hearing. The committee does not start doing its own investigation in there, however much they may want to. You close the hearing, you write your recommendations, there's nothing Brian can complain about. But when you start doing the investigation and the hearings, that is when you're giving Brian a very good excuse to say, these people were out after me. Look at the minutes of the hearing. You can see how the committee was even on my case. How are they going to listen to me when their minds are already closed? The quieter the committee is, the less it can be judged. Any complaints Brian has, he will complain about the investigator, not complain about the committee. So my advice always, time and again, for my clients is committee, kimya. Let the investigator do all the talking. You guys just nod your heads, write in your notes. When everybody has finished talking, you tell them, okay, close, out of the door, we're going to now consider this. That is all the committee needs to do. Yes, so that is what needs to happen before the hearing. Now, I am jumping into the nitty-gritty. I'm seeing we are almost running out of time. I'm now jumping into the nitty-gritty of the hearing itself. We looked at it theoretically, notification, mama. Now we're going into the nitty-gritty, and this is directed mainly to the chairperson who's in charge of the hearing. Rule number 1 or advice number 1 is about the composition of the committee. The people in the committee must, if it is one person, 2 people, 3 people, whatever, these people must not be, none of the people on the committee should be the people who did the investigation before this hearing date. And I've actually handled the case where, how many people? I think there were 4 people. The same 4 people who were the disciplinary committee were the same people who were the investigation committee. And I told the court, if they've investigated and written a report, and then later on they are sitting as the judges, how likely are they to say, these investigators did a poor job? Brian, you're very innocent. No. If they are the same investigators, they'll have to say, no, these investigators did a wonderful job. Brian, you are so guilty. So if you're the investigator and then again you're the committee, you're not impartial. You're already biased in favor of supporting your report. So ideally, nobody in that investigation team, if it was a team or even if it was an individual, none of those people should sit as a committee member. They should be separate, presenting their findings to the committee. We've already covered that. Moving on. So, chairperson, my advice is the rest of the committee, don't say anything. Chairperson should do all the talking from start to finish. Okay? So, chairperson, your duty number one is to introduce everybody. Is to say, hello, my name is Grace. I'm going to be the chairperson of this committee. I'm supported by Kevin and Catherine. They're my fellow panelists of the committee. The investigator of this hearing is Joseph, and the employee is Brian. Joseph's witnesses are ABCD. Brian's witnesses are EFG. We all know who are here, and then there's so-and-so who is here to take the minutes. Probably HR officer is taking the minutes. So we all know who we stand. So that everybody knows. And that way also Brian knows investigator is not part of the committee. It is clear to Brian. Committee is Grace, Kevin, and Catherine. They should actually advise my clients, even the way you sit, you should make it clear. You guys are on this side, investigator, you go kule, Brian is on the other side, so that the Brian can see investigator is not part of you. The investigator should not be sitting next to you facing Brian. He should be on the same side. Brian is facing you and the investigator is also facing you. So even how you sit expresses that the committee is on this side, other people on that side. Okay, that is number one. Two, I always tell the chairperson there are 3 key questions every chairperson must ask before you kick off any disciplinary hearing. 3, if these 3 key questions you don't get yes, 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 the hearing stops. You get answers of these 3 questions, the hearing, you get 3 yeses, you can proceed. And the reason why we are asking these questions, we may already know the answers. The reason why we are asking these 3 questions is because you want an answer from Brian, and you want the answers to these 3 questions to be in the minutes. You already know the answers, but you ask them for them to be in the minutes. What are the 3 questions? Number 1, Brian, do you understand that you are here for a disciplinary hearing? A disciplinary hearing is a procedure that can lead to your dismissal. So do you understand you're here defending your job? Do you understand you're here for disciplinary hearing? So you want Brian to say yes. See, I've not come here for just a casual conversation or a meeting. I know I'm here for disciplinary hearing. So you want a yes from Brian. The minute secretary captures, Brian has confirmed he's here for disciplinary hearing. Second question, Brian, have you had sufficient time to prepare for this disciplinary hearing? And you want Brian to also say, yes. I got the notification a week ago. I've studied it. I was involved in the fight with so-and-so. I know I am here. I'm ready to defend. You want Brian to say yes. Why? The rule of thumb is you must give a reasonable amount of time. And the principle in Uganda is you must give 5 days. So a week is roughly enough. And you may have, I would advise you must give minimum a week, five working days a week. But you want Brian to say yes and have it on record, so that later on he does not go before a labor officer and says, I was not given sufficient time. You say, you were not given, let us look at the minutes. I remember before we even started, you were asked and you said yes. So if Brian says, no, I've not been given sufficient time, you ask him why. What is the issue? How much more time do you need? He says, I need 2 more days. You give him the 2 more days, you come back. So that the minutes show, 1, he was aware, his job was on the line, it was a disciplinary hearing. 2, he asked for 2 more days, we gave him the 2 more days. So we gave him sufficient time. Question number 3 is, are you aware you have a right to a representative? He says yes, that is captured. So that if he's by himself, he said, I am aware of the right, I have chosen not to exercise the right. Issue of representative, there's one big difference between Kenyan law and Ugandan law on the issue of representative. Under Kenyan law, the representative is a fellow employee or a union member. That is what is set out in the Employment Act. In Uganda, an employee a worker facing a disciplinary process has a blank check. They can bring an advocate. I've had a disciplinary hearing where the employee brought their spouse, said, I feel more calm when my hubby is here. Tell me what is the issue. They can bring whoever, they can bring the president of Uganda if they want. It is a blank check. And the mistake that a lot of international employers do is, if you even look at the disciplinary rules of the UK, it also says fellow employee or union steward. So it seems the global rule is it is limited to internal people. But in Uganda, wapi, I can fly in whoever I want. And that is the biggest mistake that international employers make. They do not give the employee, they limit the employee to internal parties. And as the litigation lawyers, we say it's okay, bring those minutes. They did not give you a right to have a lawyer present. This case is open and shut, end of story. So my advice to HR managers who have Ugandan companies, be aware that you need, in Uganda, we have an employee has a blank check to bring whoever they want for a disciplinary hearing. I have very many reasons why you should allow the lawyer in there, but we are pressed for time. I think my time is even up. So anyway, are you aware of the right? You want to capture it. Then after that, you read the charges as per the disciplinary hearing and tell Brian, are you pleading guilty or not? If he says, yes, I'm guilty of everything, the hearing ends. If he says, no, I'm not guilty, that's when you say, okay, investigator, please present your case. Investigator presents, finishes presenting, you tell Brian, and you're hearing. The committee is just hearing all this and making notes, doing nothing else but hearing. We're here for a disciplinary hearing. So let us just hear. They finish, you tell Brian, ask your questions. Brian asks his questions, committee just hears, writes. Phase one is finished. You say, Brian, I'm repeating myself, but that is it. I'm now walking us step by step through the process. Brian presents, committee hears, tells the investigator, do you have any questions? What he has said, asks the question, you hear, you write. Wrap it up, go home. I'm on page, that is the end of the disciplinary hearing. And once that happens and the committee members have not been jumping in and trying to pin Brian, you are on solid ground. I do not see an employer losing, having any fault in that hearing, that the hearing was unfair. No. It is only unfair when the committee becomes active in the process. You are there to hear, let the committee just hear and write their notes and close the hearing, safe and sound. Yes, next thing, the committee now sits in camera and now discusses all these things. Another mistake that some employers, not very many, make is those minutes of that discussion, they share that with the employee. You have no obligation to share that. You have an obligation to share the other earlier minutes of the open proceeding when the employee is there. That is all. What the committee discusses amongst themselves, ni siri yao. It is their secret. At the end of the day, it is minutes and termination letter or dismissal letter. End of story. The employee does not need to know what is discussed in camera, because if you give minutes of this hearing, that is when now the employee's lawyer now starts fault finding and saying, you see, they were unfair, they were saying this and this, yet you actually have no legal obligation to share the discussions of the committee in camera. All you have to share are the minutes of the hearing. Okay, moving on to this. I'm trying to close because we're time bad. Why should we have a disciplinary hearing? 90% of the time, by the time you're calling Brian, come next Tuesday for a disciplinary hearing, 90% of the time, you know, I'm going to fire this guy at the end of this hearing. You know, most employers know. I think out of all the clients I have, I only have one. And I even commend them. I tell them, you guys are the only people I know. You keep an open mind at the end of the hearing. You actually go like, actually, no, he's proven his case. Let us not fire him. I don't know of any other company in Uganda. For reasons of confidentiality, I cannot tell you the name of the company, but that is the only client I know. They actually have a fair hearing. But 90% of the time, you know that you're going to dismiss this person. So you might be scratching your head and saying, so if we know you're going to dismiss Brian, why is the Employment Act giving this headache of holding a mock hearing where we are play acting and pretending as if, you tell us, yeah, if you really present a good case, we're not going to fire. You tell us, we are open, no, yet you know you're going to fire. Why? So I like giving three reasons for everything. So I have three reasons why it is good to have this disciplinary hearing. Number one, and this is to put a human face on the process. Number one, you as the employer, you know how you want your company to run. You know what your expectations are of the different workers. You know how you want the workers to cooperate and work together. You're like a parent. But as any parent knows, you have your plan, but the children have their own plans. They want to come and play and do as little as possible and just have a good time in the office. So for you, you might be seeing Brian's shortcomings as clear as day. You cannot, you're just even saying, like, why aren't you thinking? Why can't you see that if you behave like this, we cannot work together, we cannot coexist? That is how you're seeing it as the employer. But kama vile thinking of a child, open that space in your mind to say, maybe Brian is not seeing it as clearly as I am. okay? I see his faults. He may have a rough idea that he's doing things wrong, but maybe he has not realized it has escalated to the point where I'm going to exit him from the company. So reason number one to have this hearing is, if you are not to have the hearing, it would simply be you write a letter saying, Brian, you did ABCD, out you go. But when you have this hearing and you have an investigator laboring to explain in detail, it is a way to wake up Brian's head and let him think about himself and say, oh, I had not seen it from that point of view. Thank you. I'm sorry, I've let you guys down, but this is going to be a lesson for me. When I get the next job, I'm going to fix this thing about myself. But if you've not presented and helped Brian understand his shortcomings, he will leave your company, go somewhere else and do the same thing. So reason number one, the humane reason for having a hearing is not about kesi ya kumtupa, to get this guy out of the company. No, it is, let us explain it to him so that before we exit him out, he can work on himself and think about himself. That is, for me, is the number and best reason why to have a hearing. Let it not be a combative experience in the hearing. Let it be, investigator, please explain to him makosa yake, so that he learns from this. Let us not just send him out as ignorant as he is right now. Let us educate him kidogo, and then we send him out. So that is the best reason why you're having a hearing. And that is the attitude to put in your committee, that we are not here to crucify Brian. We are here to correct and educate in a way and give him an opportunity to learn and do better at the next place he's going to go to. So that is reason number one. Reason number two is the obvious one of, we must have a hearing so that we don't get sued for unfair dismissal. It's a very straightforward reason. I don't think I need to say more. Reason number three, and once again, this is a reason I discovered with that employer. I told you there's one employer that I love, the way they handle their disciplinaries. Reason number three is the same way you have this process to show Brian his shortfalls. This is something that this employer does. In the course of the investigation, they not only ask themselves, what did Brian do wrong? They ask themselves, where did we fail Brian? How can we improve our processes to prevent this thing from happening again? So that the investigation process is like an audit of the company's own policies and practices, etc. And usually at the end of their hearings, they say, let's say Moses should be fired because of ABCD, but we also recommend this policy be improved, this thing be done. They also have these other things of, let us make changes to ourselves to avoid this situation happening again. And I just tell them, wow, you guys are opening my eyes. So for me, that is another reason why to have a hearing, because it helps you also look at yourself as an organization and say, Brian went astray, but what is it? It takes two to tango. Brian made some mistakes, but let us also ask ourselves, where did we also go wrong and also improve from this process? So the disciplinary hearing is part of that investigation. And that is something that can be deliberated in that in-camera discussion, and the recommendations are sent privately to management. You do not have to send these recommendations to Brian, because Brian will get them and say, aha, you see, I was not, no. These are things to fafanua amongst yourselves and then pass it on to management. Say, much as we're dismissing Brian, please make these changes to avoid the situation. So for me, those are the three reasons. One, bring it home to Brian, his mistakes. Two, avoid getting sued. Three, make it a learning process for the organization as well. Yes, the committee can ask, okay, there's some questions here about how the committee, if the committee wants to ask questions. When I'm advising the committee and telling them, okay, if you really have a burning question in you that really, really must be asked, this is how you should ask it. That question has probably come out from something the investigator said, something a witness said, or something Brian said. That is usually where the question comes from. So now the formula I tell them to use in asking a question, you tell the person, Mr. Investigator, you said blah, blah, blah. I did not understand. Can you please clarify? Your question should always be tied to what somebody said, and you say, I want clarification. And then now the person explains more. It should not be, you say this thing, but how come? No, it should be, you said ABCD, but I don't understand it because of ABCD. Can you clarify how the two can be reconciled? And then the person, that is how the committee should ask their questions. That is my advice to my clients. Okay, I think I'm on my last page. Yes, I'm on my last page. Fantastic. Please, Nisameni, for going over time, but I'm on my last page. Right. Time and again, you hear judges saying, this dismissal is unfair because the employer did not follow the principle of natural justice. And I think a lot of employers, a lot of HR officers ask themselves, what is this natural justice that lawyers and judges keep talking about? I wanted to give you the principles of natural justice. And once again, in typical Emurwon fashion, there are 3 principles. Everything is just 3, Father, Son, Holy Ghost. Okay, these are the 3 principles of natural justice, and they kind of are tied into disciplinary hearing. Principle number 1 of natural justice is notification. This is independent of what is in the Employment Acts. This is taken to be natural. It is just there, vile tumeumbwa na Mungu. It is just how things should be in the natural state of being. Even when Adam and Eve ate the forbidden fruit, God being all-knowing, he knew the chaps had already eaten the thing. He knew even why they did, but he came and said, Adam, what have you done? That is natural justice of saying, even though I know, I'm going to give you the opportunity to present your case and I hear you before I kick you out of the garden. But I came down knowing I'm going to kick you out of the garden. But even God said, please let me hear from your side before I do the thing I'm going to do. So by the time God is also saying, let me hear from you, really, let us also be humble and ask. Okay, so anyway, so principle number 1 is notification. Principle number 2 of natural justice is hearing. Principle number 3 is impartiality. I'm going to explain each of the 3. So going back to notification, natural justice says, for the principle of natural justice to be satisfied, the information that you give Brian must be sufficient for him to participate meaningfully in the disciplinary hearing. That is the key word. It must be sufficient to enable him to participate meaningfully. I'll give you an example of a disciplinary process that a client of mine just went through. He was charged with fraud. He was in let me not go into too many details because of confidence. He was charged with fraud. He wrote to his employer and said, I'm being accused of doing these funny things with these documents. Can I? And okay, he was charged with fraud. They told him, hand over your laptop, hand over your phone, go home, you're on suspension, come back after 2 weeks to face the fire. Now, during the 2 weeks, he said, okay, you've told me what I'm charged with. Can I have documents A, B, C, D, so that I can also prepare on my side to explain how I did the things that I did? And the employer told him, no, these are internal documents. We cannot share them with you. So you have not given Brian sufficient information for him to participate meaningfully in that hearing that is going to happen in 2 weeks. Put yourself in the employee's shoes and say, have we given him everything he needs to know for him to come and face this thing? So that is principle number 1. Have you notified him fully? Does he fully know the charges? Does he know which section of the HR manual is broken? Does he know what? You must give him all that info. If you've not given him all that info, if the courts or the labor officer finds that you are hiding some things from Brian, that is enough to say, when you hide these things from him, how can he participate in a meaningful way? So that is what we mean by notification in terms of natural justice. Second, hearing, giving Brian a reasonable opportunity to present his views about whatever that offense is. You don't have to agree, but you must give him an opportunity to present. He may not even show up for the hearing. I've had those cases where we've caught the staff on CCTV. He sees the video. He just says, you guys, well, let's not even waste time. I'm not coming. You just do what you're going to do. But you gave him the opportunity to show up and present his views. That is what the judges and the labor officers want to see. And also to give him an opportunity to challenge the views that are being presented by others. If there are people accusing him of forging a signature, bring those people, let him question them and say, show me, when did I forge etc. In this particular case, we made a request for somebody was accusing my client of something, and we made a request that, hey, let Kevin come and explain this thing. And the employer said, I'm sorry, we are not going to present Kevin. So me, I'm just like, ooh, for me, that is fantastic. Number one, you've not given us sufficient information for us to participate meaningfully. Secondly, you're not even giving us an opportunity to challenge what is being said about us. So I'm like, me as the lawyer, I'm like, yes, thank you for all the money you're going to give my client. Number three, the third principle of natural justice is the impartiality of whatever is being presented by the investigator and whatever is being presented by the employer must be presented to a committee that is unbiased, that is not leaning on the side of the employer and is not leaning on the side of the employee. They are fair and are listening to everybody equally. That is why I advise my employer clients. It is when your committee is talking, that is when they create opportunities of being pointed at and saying, this committee was not fair. It was leaning in favor of the employer or whatever. Usually they're leaning in favor of the employer. The more they're just quiet and writing their things, the harder it is to say they were biased. The more they talk, the more they are exhibiting their bias. So whatever they have to say, let them keep it to themselves, make their notes, fukuza everybody at the end of the hearing, then now they can talk amongst themselves and discuss whatever they want to discuss and render their decision in that safe space. I'm now advising employers on how to do the thing. But if they bring out their things during the hearing and are pinning and pointing fingers at Brian, you are contravening, you're breaking the third principle of natural justice. You're showing that you're not impartial. You are actually out to crucify Brian. Even if you're out to crucify Brian, do it in your closed session. Keep quiet until you're in your closed session and then crucify Brian from there. And that is my last page of the presentation. First, questions, please, if there's time. I think we've gone over time, but I will do my best to respond to whatever there is to respond. Asante, wow. Yes.
Wow, Brian. First of all, you need to come back to Kenya. This is your home. I didn't know your Swahili was that good. I need to look for you when I come to Kampala or when you're in Nairobi, please.
Most welcome, most welcome.
Right. So we have quite 1,000,001 questions and 1,001 answers. But there's a question that has been coming a lot. Who signs the minutes of the disciplinary hearing? Who signs the minutes? Who signs the minutes?
Fantastic. A lot of my employer clients make the mistake of saying everybody who attended this thing should sign. Me, I tell them, Apana, minutes are signed by the chairperson and minute secretary. 2 people. What you want is an attendance sheet where everybody comes in and signs that attendance sheet. That is the only proof you need that Brian attended a disciplinary hearing, just the attendance sheet. But what is in the minutes is authenticated only by chairperson of the committee and the minute secretary. If Brian feels those minutes are not representative, Pole, let him, yes. But who signs, that is it. But most employers feel, no, let us pin him and he must sign here and say this is a true and correct record. Welcome to Kutu. He says, no, you add my things, other things in there. I'm not going to sign these minutes. And then now you're trapped that other people have signed and Brian has not signed. And then he goes to the labor office and says, you see, I didn't even sign the minutes. So I'm like, why even open yourself to that problem? Minutes are signed by chairperson, minute secretary. End of story.
So, and I've seen a lot of people asking, so what role does HR play in the disciplinary committee?
The role of HR, usually it is to take the minutes and to guide. Usually when somebody says, are we on the right track? Have we done the procedure very well? HR, please guide us. And another thing, by the way, the chairperson of the committee has the right to say, something has come up. Let's say you've raised a good procedural point. Can you people step out and we consult and find out the right way, and then we'll call you guys back in. And then you sit down, you unajadiliana na HR. If need be, you even call your external lawyer and say, this point has been raised. What is the right way to go about it? And then you call back guys in and say, okay, we've been guided and this is how we're going to move. But the role of HR really is to take minutes, or sometimes HR can be the investigating officer. They can, but if HR, usually if you have like a 2 or 3 man person HR, one HR officer is doing the minute taking, and then another HR officer is the one making the presentation, presenting the findings. So it can be that person, or it can be the employee supervisor who is doing it. Whoever is the best placed person to have done the investigation is the one who does the investigation and presents. Yes.
Okay, because a lot of people, and especially here in Kenya, the committees are chaired by HR, I think, for quite a lot of people.
You can do that. It depends. It really depends on how and why. But now, that is okay if the investigation, let's say, was done by the supervisor of that employee. But if HR is the one who actually did the investigation, because usually when something goes wrong, it is reported where? HR. That, hey, there was a fight, whatever. And now HR goes and starts investigating, getting a statement from this one. Now, if you've done the investigation, how do you come and now be the chairperson of the committee? You can only pull that off if it's a big HR department and it's your junior officers who did the investigation, and then now HR manager is the one sitting. But even still then they'll say, you have a vested interest in saying my junior officers did a good job investigating. So me, I would not want HR as a part of the committee. And then number two, I also do not want, my recommendation is you do not want the top management to also be in that committee. What you want is middle management to be, because when Brian says, I was not treated fairly, I want to appeal or whatever, if it has been handled by general manager, who are you going to appeal to? So you want the middle people. Yes.
Okay, and then in the age of technology, can we do a recording of the hearing?
Yes, that is okay.
And that is admissible in court?
Yes, but it's a headache to now present video. For me, you do a recording and then you reduce it to a transcript, a written transcript, and then say this is it. But I'm not really in favor of recordings because you can go into so many tangents and bring irrelevancies. You'd rather want somebody who is well trained in how to capture the minutes, and they just capture the relevant material points that bring out the facts that are sufficient to bring out the employer's case. Actually, what happens with my clients is when I'm advising or participating and guiding in the procedure, some clients tell me, we're going to have a hearing on this day, you come and guide on procedure so that we don't have to call. So I sit there quietly. When somebody raises a difficult thing, that is when the chairperson stops and says, okay, Emurwon, can you guide us? What is the best way forward? So I advise, now when that whole process is over, whoever's taken the minutes sends me the minutes and says, Brian, this is my draft as a non-lawyer. Look through, are there any time bombs in how I've recorded what happened? And then I get in there and I clean it up and I send it back to the client. And that is now what chairperson and minute secretary sign off as the final version of the minutes. For me, that is my recommended procedure if you don't want to get sued.
Yeah.
So and me doing a verbal transcript, that one you're tying your hands. There is no human being who's 100% perfect. You give somebody everything that was said, a very stubborn lawyer on the other side will pinpoint and find some tiny thing somewhere and say, on the basis of this, what happened on page 8 or page 18, my client was unfairly treated. So for me, I'm not in favor of recordings. Well, you can have the recordings, but I'm in favor of a summary of the meaning of the hearing rather than word by word recording of everything that was happening. Yeah. Yes.
Now, when we have for example, what do we call it? When somebody gets late, a lot of times, what do we call it?
Late coming, tardiness.
Yes, like it's now a habit. And they have been served with all the hearing, or rather, all the warning letters.
Warning letters.
Yes, and then here we are now. We are done, and HR is now sitting here. Will they sit as the investigating officer, or will they sit as the secretary and blah blah blah?
I have no problem with HR being both investigator and secretary. You can have one HR officer investigating, one HR. My problem is when HR investigates and then now sits as the committee. My advice is HR should never be on the committee, not even a panel member of the committee, because it's HR usually that does the investigation. And if you're on the committee, you have a mandate, a vested interest to say my investigators did a good job. So if you have that vested interest, you're not partial. So remove HRs from the committee.
Now, how do you protect?
Yes, sorry.
No, I was wondering, I had moved on from that question.
Yes,
I was wondering, how do you protect the investigators, especially because sometimes there are things that they investigate. We have, even now, one of our clients, a production manager, is being threatened by a former employee. So how do we protect the investigator, and especially when the matter is very, very sensitive? Because if they come to the hearing and say, this is my findings, we are also risking their lives. And especially on matters, for example, sexual harassment, they're things that are quite sensitive. So how do we handle that?
Actually, that one now, I don't know. We have left the realm of HR. We are now in the realm of like witness protection. I think it falls back to what I was saying of the lowest dose that is sufficient to exit this person from the organization. You may have all these things that can paint Brian as the blackest devil on planet Earth, but my recommendation is, because and you might be 100% right in all those things that you want to say, but the worse you paint Brian, the more you're making him hate himself, but he cannot hate himself. So he says, who should I hate? Who do I redirect all this anger I'm feeling? And then it is redirected to the investigator. So you tell the investigator, yes, we have this long list of the things Brian did wrong, but how much of this do we need to exit him out? Because let us also let him know about his wickedness and evil in small doses that he can handle. We cannot drop everything on him. He may have even a PTSD from the experience, you know? So you pick and say, he inatosha. There are 10 things, but these 3 are enough to bring out and exit him. Let him work on these things. When he has finished working on these 3 things, maybe we can tell him the next 3 so that it is a process. We cannot expect him to rectify all these 10 things about himself. So for me, I think from the disciplinary process of it, it is not to say all the 10 things that we found wrong, we must present all the 10 and totally destroy Brian during this hearing so that he really has no defense. No, out of the 10, just pick the 3 that are enough gently just usher him out and tell him, hizi ndo makosa yako, think about yourself, think about making things better. We believe that in the next job, maybe you will have rekebisha these things, like that, so that it is a progressive. And that's when the person says, you know what, yes, I actually know I'm even worse. They had the opportunity to even throw more on me, but they took me more gently. They treated me like a parent to a child and are trying to actually correct me. And that's when the person leaves the organization without that hate and animosity for the investigator. But most employers think, no, to make sure we win the case when Brian sues, we must really push and really convict him and show him beyond all reasonable doubt, this is actually the worst. And no, that is not the standard that the law gives you. It says, no, it is 50-50. If you can show that the reason why you fired Brian is reasonable enough. Let us say out of 10 employers, 5 would have kept Brian for having done this thing, but the other 5 would have kicked him out. That is all you have to show, that a reasonable employer would have kicked him out. Even if the court says, for me, I would have kept him, but they'll say, yes, but a reasonable one could also have kicked him out. So on that basis, you are right for having done what you did. That is the standard that an employer has to show. You don't have to show that really this guy is the most vile human being on the planet. Because when you go down that road is when now Brian says, okay, nitakupata nje. You investigator who's trying to do this to me. You get? Because you're not only firing me, but the way the information you're releasing and the letter you're going to give me is going to make sure that I don't have a job elsewhere. How do I feed my kids? How do my kids are going to be kicked out? Like all those are the issues now that stress somebody out, and he says, you know what? My only remedy is to find you and beat you up. But if you treat him taratibu, knock him out, number 1, he can work on the little that you've shown him. Number 2, he can get a job elsewhere. There is less of that animosity towards who handled the investigation. That would be my advice.
Okay. I have seen, oh God, it's 9:28. It turns out this conversation cannot end. There are quite a number of questions, and I don't think we are able to actually cover all of them. Quite important, I have seen a lot of people asking about an appeal. Can an employee appeal? And I don't know, maybe you can comment on the appeal, Brian, for like 2 minutes or so.
Okay, yes, the appeal process is there, but I am not in favor of appeals, because now, number 1, that means now organizing who is going to handle who is this new committee that is going to handle the appeal, and the appeal is not regulated by law. So you have your minutes of this hearing, you have the minutes of the appeal hearing, one decision here, one decision here, maybe both are even saying fire this person, but they are giving different reasons for the fire. I would not recommend having an appeal process. For me, it is let it be here. Let us end the suffering as quickly as possible and as gently as possible and exit this person out of the organization. So yes, you can have an appeal process, but here, even in Uganda, the judges have said it is there, but even if you show us that the employer did the worst of the worst procedures in that appeal process, it is not a legal process. It is like notice to show cause. Ni maridadi umeongeza, but it has no legal basis whatsoever. And maybe you're increasing chances of somebody complaining about your organization that you did ABCD wrong in the appeal. So why expose yourself to further risk? Handle the disciplinary hearing as well as possible. You have fulfilled your legal duty, and tell this chap, please.
But technically what you're saying is they have a right to appeal if they want to, but you don't encourage it.
If you put it in your HR process, but it is not a legal right. But once you put it in your process, your internal process, then the law says, yes, you must follow the the kazi you have given yourself. Just like if you put notice to shoppers in your HR manual, then the law says that you do it, but we don't really care, but you must follow it for yourself. So for me, I'm like, why give yourself headache? Trim away all those unnecessary processes. You are suffering, Brian is suffering, it is a headache for everybody. Yes.
All right, so Lucy, Karanja, and everyone who is asking for CPD points, if I give you CPD points, I'll charge for this session. So allow us. We actually do organize paid trainings that we offer CPD points. Please take advantage of those ones. Normally, we want to do them for a minimum of 3 hours, as the IHRM Act, or rather the HR Act provides, or rather the guidelines, the CPD guidelines, provides that we do minimum 3 hours to be able to give CPD points. So for that reason, then the Tuesday sessions do not qualify. And as well, we also pay to offer CPD points. So we would need to charge to give you guys CPD points. But I hope you're learning. I mean, at the end of the day, what you're trying to do is not necessarily make you compliant with the law of the HR, but we are trying to make sure that you do your jobs better. We want to make sure that you're treating your people and doing your jobs the best you can. So now yeah. Okay, a lot of people are getting confused. I think,
Yes.
and especially the people who came a bit late. If you came late, we will have this recording uploaded on our YouTube channel. And I have seen, I think Jacinta shared the link to our YouTube channel. But however, we'll also email the link as we say the thank you message towards the weekend, as we give you the notice on what we are doing next week. So allow us not to, somebody was asking for presentation. We do not have a presentation for this one. We only have a recording. So you can get that. There's a lot of questions that have been answered by, oh yeah, somebody is asking, how can they reach you, Brian? Maybe you can put that on the chat.
Sure. Okay, how do I do that?
Yeah. Okay.
Like, oh, let me just send a message. Sorry.
Yes. All right.
Not right now.
Grace, let Brian clear the air on investigation. HRMs cannot investigate. The public should know. Okay, I think Brian has indicated that HR should not investigate unless it's a matter that requires them to investigate. There are situations where you find yourself and they probably must do the investigation. He also clarified and said that HR's role is the secretary and the advisor to the committee. I think that.
Let me clarify. I actually do not have a problem with the HR investigating. Like I pointed out, most times when something goes wrong in the company, the place the report is done is to HR. So I'm okay with HR investigating, but you may find a situation where the report that is done to HR was done by brand supervisor. And it can even be like a technical, like let's say the report is done by the head of finance saying, I found out that my cashier is doing some funny games with the books, okay? So he's reported this to HR. Now, as helpful as HR wants to be in investigating this matter, you do not have skills in finance, you don't have an ACCA. So in those circumstances, HR anashikana na mkono with the head of finance and they investigate and advise and say, the head of finance, you don't know how to present this thing to a disciplinary hearing. So me as HR, I'm going to guide you. These are the documents you need. And HR now helps the finance person put a case together. So in that sense, HR and finance are co-investigators. But on the day of the disciplinary hearing, it will now be the head of finance of saying, I am here because I have a problem with Brian, my cashier. This is what happened. And then HR is on the side taking minutes of this hearing. And maybe if you have multiple HR officers, one will be sitting next to the finance manager, helping them present the investigation, and then another HR officer is taking the minutes. Where I've said HR should not step is HR should not be part of the committee. That is where really it is very strong recommendation. HR should never form part. So if you have a organization culture where HR manager is always the chairperson of the committee, my prayer and request is no, stop that. Find somebody else to be the committee chairperson. HR should be on the sidelines, either doing the minutes or presenting. Like this one organization that I say is my star organization. Most of their disciplinary hearings, the investigator is the head of HR. She investigates everything, talks to the supervisor, talks to all the different facts, finds, has a very nice report, and then she presents that report to the committee. but the committee is usually other people. It is not HR. And that is, I love that model. I would recommend it. HR can investigate, HR can take minutes. HR should not be part of the committee ever. Yeah.
Okay. All right. I think I don't think we can actually finish this because I am seeing now people have moved to who is signing the letter to dismiss.
Oh, I can answer that very quickly. My recommendation is whoever signed the contract appointing this person should be signing the exit. So when if you are joining the company, your appointment letter was signed by HR, it is HR to sign that you are losing the job. If your appointment letter was signed by general manager, it should be general manager telling you, hey, you know, remember I hired you, committee has told me you did ABCD. I even have a formula of how that letter is drafted. And on the basis of what they've told me, sorry, I am removing you. Oh yeah, this actually, there's a point that I had in my mind, but I forgot to make. My recommendation, usually it's possible to say that the committee, the disciplinary committee, has the power to take a decision, but I advise my clients against that. Your disciplinary committee, the height of their power should be to make a recommendation to management to take the decision. Why do I say this? Usually your disciplinary committee is composed of co-workers of this person who's appearing, of Brian, who's appearing before. And wanamurumia, they say, but for the grace of God, that could be me. And they don't want that guilt of being the ones saying, we are the ones who have dismissed Brian. So I usually tell my clients, you as the disciplinary committee, you recommend either Brian be warned or Brian be dismissed or Brian, whatever it is, the actual swinging of the axe will be done by management. And now that helps the committee not feel guilty about the task that they have to do. They listen to this side, they listen to this side, they give their recommendation. And that's also the second benefit of that, because my ultimate client is the company, it is not the disciplinary committee. The benefit of that is even in a situation where the committee sits and says, we have weighed all the evidence in their in-camera discussions, and they write the recommendation in camera. We have weighed everything, and we think Brian is innocent. Even when they write that recommendation, management, it is a recommendation. Management can say, we've looked at that, but even us as management, we've looked at the evidence, and in our view, Brian is guilty, out he goes. So it gives you that wiggle room of the committee has not fungered your corners and you're stuck. The committee does not pronounce itself. So that's something I forgot to mention. That my recommendation, it doesn't have to be that way, but the committee should, the height of their power is simply to recommend that dismiss, terminate, warn, suspend, etc. But it is management that takes the final decision. That helps the committee sleep at night, that we did not fire our fellow employee. It is management that did it. And also it gives management the room to say, okay, you've said suspend, but as we've decided, we're going to dismiss. Sorry, back to you, Grace.
Okay, I think there are different schools of thought, and especially on the part for HR, because I see Paula, and this has triggered quite a lot of discussion. Good evening. It's nice to see you, Helen Musalia, join us. Because Paula is saying, if HR is not part of the committee, does that mean they are not part of deliberations on the way forward after the hearing?
No, ideally they should not. The committee deliberates amongst themselves. HR, if the committee wants, they can call in HR and say, clarify ABCD or whatever, guide us on procedure, guide us on the HR manual. What does this offense in the HR actually mean? And then HR advises on those things. But the decision, the discussion and recommendations should just be in the committee. And that is why I advise, leave that wiggle room of whatever games the committee makes, because they can band together and say, us as employees, let us always find each other innocent. Whatever they say and give you, it is only a recommendation. And then HR now sits with management and says, the committee has recommended ABCD, but we've looked at the evidence and we have overruled what the committee has told us. But at least the committee held the hearing and heard from both sides and gathered the information for us. That is why for me, my recommendation is always, committee only recommends. The committee does not take a decision. The committee, I do not give that power. I do not recommend giving the committee that power. So that you as management, you always take the final decision. There was a question here about HR being a member. Like I said, let me jump back to the finance situation. If you have a case where a cashier has played games with the books and that situation is investigated entirely by the finance manager without any assistance whatsoever from HR. HR can sit as a committee member because it is an independent, like I said, we don't want to mix investigation and judgment. So there, finance manager will come, present the case, HR can be part of the panel. But if HR has been involved in the investigation in any way, shape, and I will actually give an example of a case where drivers, an organization, an NGO had hired new drivers to join the organization, and the old drivers started teaching the new ones how to siphon and sell fuel from the organization vehicles. So the new drivers went and reported to management and said, hey, you guys, thank you for the opportunity to work here, but we want to tell you, we're being oriented we're being oriented into ways of defrauding the organization. So they whistle blew, company swung into action, investigated, had a disciplinary hearing, fired about 8 drivers. Who are they, 15? I can't remember the number. Let us, for sake of the story, let's say about eight drivers were fired. The drivers went to court. This is a case where the organization even brought the new drivers to give evidence. They said, yes, Brian was telling us, you park it over here, you talk to James, James comes with the jerry can. They had all the evidence, but the NGO lost the case simply because one of the people investigating that fuel theft sat as a member of the disciplinary committee. That was the only basis. The organization lost that case, and they had to pay these drivers the equivalent of, I'm trying to do the math and convert to Kenyan shillings, the equivalent of, is it 24? 240,000 shillings? Yeah, 240,000 Kenyan shillings to each driver who stole fuel from the organization. 240,000 Kenyan shillings, just because this one person sat here and then again sat here. So that is why I say do not mix investigators and committee members. Let there be a China wall dividing those two. If HR does not participate in investigation, it's okay. But most cases are reported to HR. So most often than not, HR will be part of the investigation. So my advice is just keep HR out of it. It keeps things very simple.
Like, do they sit and listen in?
Yes, they can. The same way I also come, sometimes I'm called in and I'm told, HR is here to guide us on procedure when we have difficult things. Yes, but they are not.
I think that is the part where it is bringing a lot of misunderstanding.
Yes, no, you give HR a chair on the side. Yes, you give them a chair
as an advisor.
HR sit there when we need you.
Mm.
Yes, exactly, as an advisor. That is their role, and that is what the chairperson now makes clear at the start. Says, this is my committee. Here is the investigator. HR is here to advise. HR is also, this other HR person is also here to take the minutes. You are the accused. The chairperson needs to make clear what everybody's role is in the room, but says the decision is being made by here the committee. HR is only here to advise us on the process and whatever questions technical questions we may have regarding it.
Yeah, I think that was the clarity, because the understanding that was going around is that HR should be left completely out. And
no. Just saying they should not be on the committee, but they can be in the room as advisors. Yes. What this company, my number one company is, HR presents the case and then I sit there as the advisor. I'm not part of the committee. When the committee is deliberating, I'm also kicked out of the room. But when they have a question or two, they call me in and say, apart from summary dismissal, what else? And then I advise them on things like that. So HR can also play that role, but they're not on the committee. Okay. Yeah.
Sawa. So I think we cannot exhaust this one. It's already 9:44 and you know you need to go to your village.
I'm telling you, this thing takes me 3 hours. That's why I was like, we're going to do this in 30 minutes. Let's try. The whole morning training session. Yeah.
Yeah.
But I enjoyed myself. I hope I did not move too fast, and I hope people picked up something good.
You know, of course, we picked up quite a lot. And Chahens, I know you came late. Please go back to Brian's conversation and listen to what role HR plays in the disciplinary whatever. I know we will never finish this one, because you and Helen, when you start arguing, we will never ever finish this conversation. So no, I will not go on. Allow us to end this session, because there are no slides, Nekesa. We do not have slides. Brian,
I just have my handwritten notes. What I can do is maybe type this up and then send it to you, Grace, and then you can distribute. I just scribbled my key points, but I can type this up.
No problem. And there's a recording. So if anyone wants to make notes, they can go to the recording and do their own notes. Yeah. So for that reason, then please, we have a YouTube channel, and I think Jacinta had shared. So yes, I hear you, Helen. I hear you, Chahenza. Maybe I used the wrong word as argument. I just said that you guys had a discussion. You're having a discourse. And I know it will never end. And I understand. Chahenza, thank you very much. We will have you next time to tell us about the appeals. Today, we were just only focusing on disciplinary hearings. And in case we have not answered your question, please, we apologize. And we hope that next time we are able to, because this one we had to squeeze in because of time and all that. So thank you very much because of your contribution. Thank you very much, Brian. Thank you. We really thank you for sacrificing your evening. We really appreciate it.
I've had a wonderful time.
Thank you.
Even me, I'm very grateful to you, Grace. Thank you so much for inviting me. I'm honored.
Thank you so much. So you can join our WhatsApp group for those on the chat. I think the WhatsApp group has been shared with you. We will share what is coming up next week on Get It Right with Atara Solutions. And of course, if you wish to get in touch with Brian, Kevin will share out his email address again so that you can take advantage and also reach out to him. For those in Kampala, he sits right near the Ministry of Labor, somewhere near the Ministry of Labor. You can always get in touch with him. But other than that, thank you so much, guys, for being patient. It's almost 10 o'clock, my God. Hey. Yeah. So thank you very much for your patience. And you can actually read through the chat. There are quite some questions that were answered on the chat. Please go through, and maybe we'll give you about 5 minutes to go over, and then maybe you can learn a thing or two, and then we will share the recording so that you can also make your own notes and refer as a point of reference. And thank you very much for that. Somebody is saying, please share the WhatsApp group link, Kevin or Jacinta. You can help us do that. We even forgot to check whether Facebook had questions. My God.
Grace, thank you so much. Unfortunately, the Facebook family were following, and the questions that were being asked on Zoom were just enough to capture almost every question that was being asked on Facebook.
Yes, thank you.
Yes.
All right, no problem. We are good to go. So discipline management is quite heavy. It is absolutely very heavy. We had a discipline management training for 3 hours the other day. We could not exhaust. And we had decided that we leave a whole hour for Q&A. We still did not exhaust. So I know these things, we will continue trying to see how we can balance them. So okay, thank you, Lois. You know, some of these things you give an opinion as much as you give the law. So we understand the different discourses, and it's good, it's healthy, it's good to have that conversation. So thank you very much, guys. Please allow us to go and sleep as well. We appreciate you. Thank you. Please follow us on Instagram at Atara Solutions, like our Facebook page at Atara Solutions, subscribe to our YouTube channel, Get It Right with Atara Solutions, and of course, let's see you next week on Tuesday from 8 p.m. My God, I think we need to change our flyers from saying to 9. Last week we ended at 10. Today we are ending at 10. I do not. But yes, thank you very much. I am happy that somebody is still asking for the WhatsApp group link. Maybe Kevin, you can share that. So thank you very much, and we hope to see you again next week from 8 p.m. And those of you who wish to attend the Women in HR, please let's meet in Mombasa at the Sarova White Sands. I hope most of you can sign up for that one. Let's attend that conference. It's going to be rich. We have Frida Owinga, we have Sarah Richson, we have Esther Katiba, we have Henry Opondo, we have Florence Oginde. And we have Mildred Ngesa. We have quite a rich program for those 3 days. So make sure that you join us. Other than that, please register for the Genos Emotional Intelligence Coach. And yes, can men attend the, yes, Chahenza, please come for the Women in HR. We agree. We could use some testosterone in the room. But yes, so thank you very much. Have yourselves a lovely, lovely night. Brian, thank you. May God bless you. May God enrich you. May God expand your boundaries. Thank you for giving to us so willingly and so open-heartedly. Thank you very much. And have yourself a good night. We'll talk on phone.